And for Twitter to permanently ban my account for what they perceive as COVID misinformation is quite a concern, because the information that I shared is actually from the CDC website, which is a government website.
Now, with this Twitter event, my wife and I have racked our brains about what is likely to have been the tweet that triggered this. And, you never know.
Big Tech recently banned 2 additional prominent social media accounts, those of Congresswoman Marjorie Taylor Greene and of inventor of mRNA technology, Robert Malone. What is less clear is why their accounts were banned. If it's not anything specific they said, why are so many prominent accounts being banned by Big Tech, and at whose behest? The answer to that question lies squarely in what is known as Section 230. Section 230 is the 1996 law that exempts social media companies from liability for what their users post. Without Section 230, big social media companies could not exist. And so it is that these companies will do anything to ensure they keep Section 230 protections, including doing the government's bidding to deplatform unwanted voices. Hi everyone, and welcome to Truth Over News with Jeff Carlson and Hans Manke.
It's time to move past the tired argument that Big Tech can ban anyone they want from their sites and services simply because they are protected by the First Amendment. It's not the protections provided by the First Amendment, nor the First Amendment itself, that we take issue with. In fact, it's quite the opposite. The First Amendment was put in place to provide protections against government-driven censorship of free speech, and it's exactly that issue that we find ourselves concerned with. Large tech companies have aligned themselves with those in power, both from the Democratic Party and the DC bureaucracy, in a coordinated effort to silence conservatives. Some individuals are banned outright, and huge numbers of accounts are throttled, whereby their impact is artificially limited. When these actions are being taken on behalf of various elements of government, the argument of First Amendment protection becomes a counter-argument of First Amendment violation. How do we know that the government is coordinating with Big Tech? Because they have told us that's what they do. The Biden administration admitted in February 21 that it was engaging directly with social media companies to remove anything that it deemed to be misinformation, noting that we are talking to them so they understand the importance of misinformation and disinformation and how they can get rid of it quickly. The White House's self-described initiative was to ensure that so-called misinformation does not start trending on platforms and become a broader movement. Facebook has since confirmed that it provides the White House with assistance routinely. A Facebook spokesman said that they reached out to the White House to offer any assistance we can provide, and simultaneously announced a new policy to remove COVID and vaccine misinformation, along with pages, groups, and accounts that spread such material. Facebook's collusion with government goes beyond COVID. Facebook CEO Mark Zuckerberg infamously privatized elements of the 2020 presidential election when he sent nearly $500 million to local election boards in key states to turn out likely Democratic voters. Twitter also confirmed that it's in regular communications with the White House on a number of critical issues, including so-called COVID misinformation.
While some might be tempted to argue that certain types of free speech suppression serve a valid goal, the Constitution does not allow it, and for good reason. The First Amendment says that Congress shall make no law abridging the freedom of speech or of the press. The framers acknowledge that not all speech is ideal or even desirable, but they also recognize the detriments of outlawing what is thought to be undesirable speech. The inherent problem is that we can never draw an accurate line between what is desirable and what is undesirable, nor should we attempt to do so. And whatever line might be drawn may also move over time. The First Amendment was later interpreted by Justice Oliver Wendell Holmes in the 1919 Supreme Court case Schenck. Holmes stated that speech could only be banned if it incited imminent lawless action. While Holmes's ultimate judgment in the case is now regarded as flawed, his famous analogy of someone falsely shouting fire in a theater and causing a panic remains the standard for defining protected speech. Government-sponsored censorship is not only illegal but also extremely dangerous, as there is no one to police the issue. Why would the government investigate itself, especially when the current administration and the Biden family in particular is the main benefactor of the censorship? But even a change of government is unlikely to change matters. We know that much of the free speech suppression we have witnessed over the past few years happened on Trump's watch, during a period when the GOP controlled both chambers of Congress, and yet nothing was done about big tech censorship. Time and again, Republican members of Congress talk about big tech censorship, but when they've had a chance to do something about it, they've done nothing. In some cases, this is almost certainly because they are themselves in a very cozy and profitable relationship with big tech. Big tech lavishly donates to members of Congress on both sides of the aisle. In answer to the timeless question of who watches the Watchmen, the answer appears to be that those who are funded by the ones who they are supposed to watch. The line between government and big tech has also become increasingly blurred, as large numbers of positions in big tech companies have become de facto retirement careers for the former hierarchy of the Washington elite. These include Facebook's Stone, Twitter's Jim Baker, better known as the former chief FBI counsel, and of course, Miles Taylor, the Homeland Security official who joined Google after he was outed as anonymous, the infamous bureaucrat who regularly badmouthed Trump. There are also high-ranking government officials with family members operating within big tech, exemplified by Fauci, whose close relative happens to work for Twitter. Nor is this simply a domestic problem. After completing his tenure as Deputy Prime Minister of the United Kingdom, Nick Clegg became Facebook's Head of Global Affairs, a position he holds to this day. In addition to financial incentives, the government has big tech exactly where it wants it, in a dependent role whereby Section 230 can readily be wielded as a heavy club if big tech were ever inclined not to comply with the government's wishes, such as deplatforming certain individuals.
As mentioned at the outset, at its core, the issue boils down to Section 230 of the Communications Decency Act. Big Tech's business model is built on the continued immunity from litigation provided by Section 230. They'll do anything to maintain that protection, including doing the government's bidding and acting in conveniently partisan fashion. Leaving Section 230 in place in its current form ensures that big tech will continue to operate as an extension of government power and control. Based on what we've seen from the GOP, the current establishment system is far too cozy to expect any meaningful legislative changes. Perhaps it's finally time to address the larger First Amendment issues. Thanks for joining us on today's episode of Truth Over News. Real investigations, real analysis, no narratives.